So we had a major legal update out of the Second District Court of Appeal here in Florida this week that changes the game for criminal procedure and search and seizure. So what you need to know is that generally speaking, the Fourth Amendment of the United States Constitution protects citizens from unreasonable searches and seizures by law enforcement. So what does that mean? It means that in general, if the police want to conduct a search of you or your car or your property, that they need to have a warrant, or there needs to be some exception to the warrant requirement. One of those exceptions that has been on the books for quite a long time is what is called the plain smell doctrine. And what the plain smell doctrine means is that if the police encounter a citizen and they smell marijuana, that they could conduct a search of the person and the car, if they're in a car, to see if there's illegal contraband. Well, there was a new opinion that was authored just this week on October the 1st out of the Second District Court of Appeal here in Florida. It was Williams versus State. And the argument by the defense counsel in that case was, given the legislative changes both at the federal level and at the state level about marijuana over the last decade, that the plain smell doctrine is no longer valid. And the idea was, with medical marijuana and with legal hemp, that plain smell alone is not indicative of illicit or illegal use the way that it used to be when it was all grouped together. So what the court found was that although the smell of marijuana could give some indication that there could be an illegality, that fact no longer will permit a search of a car. So as of this week, plain smell no longer exists here in Florida.